Jane Kreusler-Walsh here on behalf of the appellant, E.I. DuPont de Nemours, who was the defendant in the trial court. With me is my associate, Rebecca Mercier-Vargas, and my trial counsel, Tom Schraus. With the court's permission, I'd like to reserve 8 minutes for rebuttal. We've appealed from a $14 million judgment entered for an Ecuadorian shrimp farm who prevailed on an unpled failure to warn claim that is barred by FIFRA. The trial was littered with evidentiary errors that included an improper exclusion of our expert witnesses, unscientific, unreliable evidence that was admitted, and improper limitations on our cross-examination. Most basically, DIBSA prevailed on an unpled failure to warn claim. If you look at their complaint, you will see that they alleged 3 specific acts of negligence: design, distribution, and testing. You will nowhere find the word warning, the word label, or the word registration. The reason for that being very simple. They knew when they formed this complaint that any warning, label, or registration claims would be barred by FIFRA. We filed a motion for summary judgment citing FIFRA. They filed a response. In that response, they said, DuPont's characterization of our complaint as alleging a failure to warn claim is disingenuous and not an intelligible reading of the allegations in this complaint. 5 days before trial, after the court has denied summary judgment based on FIFRA, they stand before the court and they say that the general allegations of their complaint include warning claims. The trial court agrees with them over...
On the motion in limine?
Pardon me, Your Honor?
This was on the motion in limine?
Yes, the motion in limine to exclude evidence related to labels and warnings. They stand before the court at that point and they say, it's in there, it's alleged, we have warning claims. The case goes to trial. They put on evidence after evidence after evidence of failure to warn, failure to properly label, registration arguments. After the jury has retired to deliberate, the jury returns with the question. The question being, Your Honor, we have a partial verdict. We have found for the plaintiff on the failure to warn claim. We have found against the plaintiff on the negligent distribution claim, but we can't reach a consensus on negligent failure to test. So the judge says, you got to go back and you got to reach something. At that point, after the jury retires again to resume deliberations, Mr. Campbell stands up and he says to the court, Your Honor, I move to amend my complaint to allege failure to warn to conform to the evidence. DuPont again vehemently objects, telling the court the time and time again, since well before this trial ever began, there was no failure to warn claim in this complaint. The trial court denies the motion to amend. The jury comes back. They find for DuPont on the failure to test, leaving only one claim before this court today, that being the negligent failure to warn. Under the Supreme Court's opinion in Archie-Fried, that claim should never have gone to the jury, and the fact...
This was discussed before the trial. Then it did come up before the trial, didn't it, with respect to the fact that their claim was included failure to warn?
5 days before trial, Your Honor, that's correct, in response to our motion to exclude their evidence. That's when they announced.
Hadn't that come up in the discovery process as well?
It had come up in discovery, and that's in fact why DuPont had moved for summary judgment based on FIFRA. What happened was the plaintiff was allowed to have it both ways. They defeated the summary judgment on FIFRA. They filed pleadings and stood before the court saying, we have no label claims. We have no claims that challenge the label on this product. And then 5 days before trial, they stand before the court and they say the exact opposite. And then if you review this transcript...
Did you ask for a continuance at that time?
No, we did not, Your Honor, nor...
You could have asked for a continuance.
We could have. We asked for a continuance on other grounds.
But you knew going into the trial then that failure to warn was going to be an issue.
5 days before the trial began, we knew. This hearing...
And you didn't, your side didn't seek a continuance.
We sought a continuance, Your Honor, but not on that basis. We sought a continuance based on multiple bases, the most compelling being DIBSA's failure to produce thousands and thousands and thousands of documents that we did not get even during the course of the trial. But be that as it may, the answer to your question is no. And the second part of my answer would be, and it's not required. There's nothing in the case law that says that we have to move to continue. The point of the case law is, if they prevail on a claim that isn't pled, we're entitled to a directed verdict. And that's what DuPont is entitled to today. And if this court were to find for some reason that the claim was pled, then we have to move on to the FIFRA analysis. The trial court found that FIFRA did not apply in this case because this benlate was exported to Ecuador. If you look at the FIFRA statute, you will see there are two provisions that you need to pay attention to. The first is 136.0, which speaks about exported products. Then you have to pay attention to the very federal regulation that they cite in their brief, which is 40 CFR Part 168, Subpart D. And you will see in that Code of Federal Regulation article that the EPA is specifically meant to regulate products made, manufactured in the United States, and sold for use in foreign countries. Even if you look at the face of 136.0, you will see that it says the export provision applies to products intended solely for export to foreign countries. Benelate's produced, manufactured, and distributed in the United States. It is not produced, manufactured, and intended solely for distribution to foreign countries. No matter how you look at the FIFRA issue, this is a product that is regulated by the EPA and governed by FIFRA. They don't even make any attempt in their brief to say that this failure to warn claim would not be barred by FIFRA if FIFRA applies.
And FIFRA applies because they are trying to bring a state tort claim.
That's correct, Your Honor.
Which would be preempted.
Right, which is the second part of our analysis. They choose to sue DuPont in Florida State Court. They chose to be bound by the common law of Florida. The common law of Florida clearly includes FIFRA. They also chose not to file a notice to rely on foreign law. So as this case is before this court today, we have the FIFRA defense and we have a preemption under the FIFRA defense, which is the second reason why this court should enter judgment for DuPont. The third reason is this case went to trial on totally unreliable, unscientific evidence. The most basic being a report from a laboratory in California called CLT Technologies. That report was done on one day. It was a sample from one of 51 ponds. It reported MBC. It reported as finding MBC in the hepatopancreas of the shrimp. We know from this record that no one can tell whether or not the MBC degraded from benlate, from Benamo, from thiophanate methyl, or from MBC itself used as a fungicide.
Well, wasn't there evidence, testimony that it contributed to that?
No, Your Honor. The point of this is MBC can degrade from 4 different chemicals. And their people admitted that there is no way to tell which of the 4 chemicals it came from. What they did, what their people did, was instruct CLT Technologies that if you find MBC in the hepatopancreas of these shrimp, then you are to perform a calculation and determine how much Benamo it would take to reach that amount of MBC.
Okay, so what you're saying is that the methodology that they used in conducting these tests did not meet the criteria of good science, and that the chemical calculation, the chemistry, analytical chemistry they used in the calculations was wrong.
That's correct.
Okay.
That's assuming they've even met the predicate for admission of a business record, which we say they have not because unknown Ecuadorians collected these samples. CLT did not. CLTs had their people collect the water and the sediment samples. Mr. Briggs and Mr. Reeder from CL Technologies said they don't know who collected the hepatopancreas samples. They don't know who dissected them. They don't know how the dissections were performed. They also say that we didn't know what sampling techniques to use or what extraction techniques, so we had to invent those methods. And then the icing on the cake comes when DuPont needs to get the backup to determine whether or not these tests have been performed accurately, and we come to find out that CL Technologies has destroyed all of the data. A destruction that Mr. Reeder from their lab says affects our ability to gauge the reliability. He said, I needed the backup when I looked at this test and I went over the calculations. DuPont needed the backup too. And the fact that it wasn't there contributes to the untrustworthiness of these tests. This test, by the way, Your Honors, formed the absolute linchpin and the only piece of evidence linking Benamil to DIBSA. And Benamil, let me remind you, is not Benlate. Benamil can be Benlate, but it also can be generic Benamil. And you need to keep that in mind when you're analyzing the issues in this case.
Back step a bit to the beginning of your argument about these tests, though, about the fact that they didn't know the proof that it came from the benylate.
Yes.
There was evidence as to what percentage of benylate was being used, wasn't there, relative to these other possible sources?
That's correct, Your Honor.
And there was a huge increase in the amount of benylate just prior to the the problem with the shrimp.
There was an increase in the amount of benylate exported into Ecuador.
A huge increase.
I don't know that I didn't characterize it as huge, but I would agree that there was an increase, and certainly enough that a person looking at the issue would be concerned.
And so why couldn't the chemist or whoever's making the analysis take into consideration what percentage or what, even if it's in gross terms, might logically be applicable to benylate? Because
it's not the scientist's job to perform those inferences. It's the scientist's job to take the chemical and determine whether or not that chemical exists in the analysis. And we know from the report itself and from another letter that's in the file from Mr. Delfini to the lab that the only reason they reported the MBC as coming from Benamil was because Mr. Delfini told them to. The scientist also said he could have just as easily told us to calculate for thiophanate methyl. He didn't, and by the way, we couldn't, and we told him that, and we asked DIBSA to please send us some more hepatopancreas samples so we could test for the thiophanate methyl, and guess what? They refused to supply the additional samples, the reason being their target wasn't thiophanate methyl. Their target was benlate. Another reason why this test is inherently suspect, because we say it was performed in anticipation of litigation. This moves us into the next issue that we contend is another science issue, again, grossly affected with unreliability, and that being the admission of their experts in Triago and Jimenez. These are two gentlemen from Ecuador who had a theory that tilt and calixin, two chemicals used to combat black sigatoga in Ecuador, combined with benlate, cause Toro syndrome. Toro syndrome, a disease that they characterize as a unique lesion present in the cuticular epithelium of shrimp. Very important. We know from the testing that they purported to do that no one was ever able to replicate their studies. No science. The peer-reviewed literature absolutely rejects their studies as scientifically invalid.
What evidence that at the Fry hearing only Intriago and Jimenez testified? Is that correct? To support the plaintiff?
To support the plaintiff. That's correct.
Okay. Then what did they rely on to show general acceptance of their principles and methodology in particular, and how they did this?
They claim to have used, the most important one is Intriago. He claimed to have used the Cox and River postulates in doing his analysis, and that would eliminate
those are the theories
and
the principles. What about, how did he support the methodology?
He did not, except through his own assertions. And that is the reason we claim the bald assertions of the scientists performing the test do not supply the scientific acceptance for the test. Most basically here, even if you were to look...
The conclusion that you're attacking here being, though, that the lesion is caused by this, right, by these chemicals.
The conclusion that we're ultimately attacking is that toxins cause... That's correct. They were tested.
Lesion.
Right.
Now, is my understanding that their argument isn't based on the lesion, though, is Am I wrong about that?
That's what their brief says, Your Honor, but if you read the testimony that we quote of Dr. Intriago and Dr. Jimenez, their testimony says with 100% certainty, as does the 1994 Arizona workshop, as does every single scientist who has peer-reviewed this issue, say that Toro syndrome is the lesion. Toro syndrome does not exist in the absence of the lesion. Intriago says, I proved that the combination of tilt and calixin induced Toro syndrome because I replicated the Toro syndrome lesion with that combination. So you cannot separate the lesion from the analysis. The lesion is Toro syndrome. Dr. Intriago at the Fry hearing said, to use his words, I would be speculating to say that anything except tilt and calixin caused Toro syndrome because I did not test anything but tilt, calixin, and histamine, another product that's not related or relevant here today. He did not test benylate. He said that in his own words. Because he did not test benylate, there is no underlying scientific proof for his theory articulated for the first time at trial that benylate plus tilt and calixin caused Toro syndrome. The science just isn't there. The science proves that Toro syndrome is caused by only one thing, and that thing being Toro syndrome virus. Yes, Your Honor.
Was he expressing an opinion based on a test, or was he expressing his opinion based on the overall fact scenario that was presented to him?
Which opinion, Your Honor?
The one you were just referring
About
to.
benylate?
Trial.
The whole basis of that opinion at trial was his test with tilt and calixin combined with the increased exports of benylate into Ecuador and the finding of MBC in the shrimp hepatopancreas. Those are the bases of his opinions.
But his opinion isn't based on the fact that he conducted this test. His opinion is based on the fact that, among other things, he did a test that showed that these other toxins could be responsible for the lesion.
No, Your Honor.
No.
He said, in my opinion, benylate, well, even though I haven't tested it, when combined with tilt and calixin will perform exactly the same way as tilt and calixin did, and it will produce this lesion. His opinion was it causes Toro syndrome.
His opinion is being expressed. What was his? He is an expert in fish, in shrimp. Shrimp what?
He's a microbiologist.
He's a microbiologist, and he is, as I recall at the beginning, he was one of the few people that was qualified to conduct this inquiry in South America. Was it? Am I wrong about that?
I don't know. He is coincidentally employed by Delphini, who is the head of the Toro syndrome group that hired CLT Technologies and also owner of a shrimp farm. So it's our opinion, and this was brought out ad nauseum at trial, that Dr. Intriago, as does Dr. Jimenez, has a vested interest, a personal stake, and an institutional bias here. He had a reason to want to find a toxic etiology for Toro syndrome, because if he did, then he could target the manufacturers of those fungicides and hope to recoup the money that they had lost with the shrimp deaths. But as I said, the science shows that benylate forms an entirely different lesion than does Toro syndrome. Benylate acts differently than tilt and calixin. Tilt and calixin inhibit molting. Benylate affects cell mitosis. They won't even work the same way when combined together. The bottom line here is that they did not prove by a preponderance of the evidence the general acceptance of their principles or their testing procedures. And for that reason, the trial court erred, not abused its discretion, it erred because we're talking about a de novo standard of review. It erred in allowing in any evidence.
When we're looking at a Fry hearing and trying to determine whether or not the proper procedures were used in testing and things like this, the evidence that comes in is usually evidence from the plaintiff or the defendant, plaintiff's experts and the defendant's experts. And it seems to me like most of the time when you're attacking the plaintiff's experts, what you're doing is using the testimony of the defendant's experts to attack the plaintiff's experts. And yet, it seems to me to be a problem in that you're not like bringing in some independent expert, some court witness. Now, I'm not talking about you in this case. I'm
I
talking
understand.
about in general. You're not bringing in some independent court witness to testify as to what's wrong with the procedures or what the proper testing procedure should be. you're using one of the advocate's witnesses to take away everything that is being said as a matter of law by the plaintiff's witnesses. Isn't there a problem in that in general?
Well, I think that there might be, Your Honor, but what makes this case so unique in that respect is our primary witness was Dr. Leitner. Dr. Leitner was originally hired by the plaintiff as their expert. He was hired when the shrimp deaths first started to investigate what was causing these shrimp deaths. Dr. Leitner is the one who did the test with benlate. Dr. Leitner is the one who, with Dr. Brock, discovered the Toro syndrome virus. Dr. Leitner is the one who looked at DIBSA slides from 1993 and saw Toro syndrome virus there. He's the one who said, benlate plays no role in this. He's an independent scientist, Your Honor.
If you don't count the case that we had a couple years ago on the Cigatera case, if you don't count that case, what's your closest authority for your position, your Fry position here?
We have Berry. We have Murray, which is a case that just came out of the Supreme Court, the Ramirez case out of the Supreme Court, the Klebel case. I can't remember if Klebel is a Sigatoga case. The Holy Cross Hospital is also on point, the Maroney case. There's a plethora of them, Your Honor, and actually I don't need to go to a best case because every single one of them supports the basic, very basic propositions that we are arguing here today. Moving on to the issue of Horst, who is their second expert and the proponent of their second theory. That being, Your Honor, did you have something? I'm sorry. That being that benlate is an indirect cause of the shrimp deaths because exposure to benlate could have weakened the shrimp. It's our position that the court abuses discretion in allowing Dr. Horst to testify because his science is missing. His experiments are not even remotely close to the conditions that existed at DIBSA. And finally, the facts of his experiments have nothing to do with the facts in this case. He started early on testing tilt at plaintiff's counsel's request. He did a test on tilt to determine is it toxic to shrimp and what is its effect. Well, the effect was what he expected it to be, that it inhibits molting. Then in March of 2000, after DuPont had been sued, and shortly before this case was set to go to trial, plaintiff's counsel contacted Dr. Horst again and said, I want you to stop testing the benlate the tilt that you've been testing for 3 years and switch now to benlate. And they formed a hypothesis that they could expose shrimp to Benamil and determine whether or not that Benamil had an effect on the shrimp. So what he did was he took a certain amount of Benamil, he put it in some water, he exposed the shrimp to that, and he found in his opinion that they elicited what he called a stress protein. And he said that that stress protein would cause the shrimp's immune system to be weakened so that they would be further threatened or more easily threatened by a pathogen or something else in the environment. The problem with his test is that he put the Benamil in the water. We know in this case that there was no MBC found in the water or the sludge. That in and of itself renders his science totally dissimilar from the conditions that existed here. He also did not put the tilt in the water with the Benamil. He claims that tilt and benlate have a 1-2 punch. But where's the 1-2 punch? He also said that the amount of tilt that was in the water would kill the shrimp outright, while the amount of Benamil that he presumed would be in there would not be enough to kill them. It would only stress them. His theories just have no application to the actual facts of this case. And finally, to make matters worse, this case went to trial with DuPont having no causation experts. The trial court excluded Dr. Roth and Dr. Solomon because for Dr. Roth, he felt that he did not have the credentials to testify in the same area of qualifications as the plaintiff's experts, and with Dr. Solomon because the court ruled that his opinions were based strictly on the literature. As far as Dr. Roth goes, he is an epidemiologist, he is a statistician, and he is a mathematician. He was the highest ranking statistician for the EPA. He routinely...
The argument here is that the science here is broken down kind of like with DNA, where there are different people who who are different experts who need to testify as to different parts of the whole analysis to get to the opinion. Like
That's correct.
In DNA, you have the molecular chemistry, and then you have the statistician. And he was in a different area, but still a statistical in one area, even though he wasn't the microbiologist or whoever. Is that?
That is exactly correct, Your Honor. He was not meant to testify as to the validity of Intriago and Jimenez's tests. He was there to testify about CLT and that test and the correlation of that test to the evidence to this case. That is exactly what epidemiologists do. If you look at the Berry opinion, the Berry court goes on and on and on and on about how important epidemiology is. Dr. Solomon is a scientist who's been working for over 30 years in the field of experimental and environmental toxicology. He has over 150 peer review articles. He was the one who was going to testify about Jimenez, about Intriago, about Horst, and also about CLT. He did review the literature, but he also used his over 30 years worth of experience in this field to form the opinions that he gave at the Fry hearing and that he would have given at this trial that directly undermined the witness's testimony in this case. With the court's permission, I'd like to reserve the remainder of my time. Thank you.
Okay, at this time, we've got to take, before you start, Mr. Rowe, we've got to take a short, how much time do we have?
10 minutes.
Beg your pardon, but we've got to take a 10-minute break at this point.